SC.READ, Inc. versus Seminole County School Board. Proceed when you're in.
My name is Alex FINCH, and I represent the appellant, SC.READ. And before we get started, and it's an injustice not to have someone who said "Go Gators" for the game last night, so I want to get that out. Go Gators. It's a pretty thick brief on both sides in this matter, and the issues for the court are aware predominantly two. One is whether the trial court departed from or failed to apply appropriate law, presidential law, and secondly, whether or not the order of the administrative agency is arbitrary in some fashion, so as to not be invalid. The underlying factual basis of this case is there was a school rezoning, and the appellees have promulgated a rule which sets forth a procedure by which they will engage in the rezoning of children. It's a very specific 10-step process, and although it does not say within the rule that it is meant to be a negotiated rulemaking under Section 12054D, that's exactly what it does. It creates a group of people to go through the facts, to come up with plans. Those plans are supposed to be reviewed in workshops. At the end of the core committee is the name of the group of people who make the rules. They come up with plans that are given to the school board, and the rule says that they will adopt one of those plans. There are no other plans provided, none from the superintendent, none from a passerby on the street. They will adopt those plans from those plans that are forwarded by this core committee to the school board.
What if the core committee only proposes one plan? Is the school board required to accept it?
Yes, based on their procedure and their policy, because within that procedure and policy, there's a district school board representative that governs that process, that gives them the information, that watches over them while they are disregarding, while they're getting rid of plans. They have delegated the authority to determine which plan is acceptable and which plan is not acceptable, and they have incorporated within that plan the discretion of the obligation of the superintendent to recommend, because it doesn't go from core committee to school board. It goes from core committee to district school zone representative. In this case, it was a deputy superintendent. Then it goes to the school board, and that happened here. And it went up to the school board, and for other reasons that will be addressed in another appeal, they came up with, no, we don't like this, so they sent it back to the superintendent, who prepared a plan that never went back to the core committee, was never reviewed by the core committee, was never part of a workshop, and was ultimately adopted after a public hearing where only commentary was allowed from the public. They came up, were able to speak for 5 minutes, say, I don't like this, or let's do something else. But it was never part of a workshop with that core committee where the delegated responsibility had been given. The policy is clear. It's very specific. It's set forth in the initial brief. It's a 10-step process. When an agency comes up with a rule, they're bound by it and has a full force and effect of law.
What's the significance of the words "for consideration" in step 10 then? Is it step 10? Where is "for consideration"?
I'll have to get to it, Your Honor.
It's in step 9. The board selects a plan alternative for consideration.
My reviewing of that is for them to determine to accept it, or alternatively to send it back and not accept it for the core committee to come up with another plan. You can't cut out the core committee. They're the ones who review the factual situations. They're the ones who have already cut out plans that have been brought in by people from the public. There were 50 plans they're denominated by A through K through J. But they went all the way up to Z and A, and they went through and they cut them out and whittled down to what they thought met the requirements that were given to them at the beginning of the process. And it was approved by the superintendent and the deputy superintendent, and then news of the board leaked out to the board, and they say, no, we don't like that. So we're going to scrap the process, scrap our policy in the process. It wasn't just 9 for consideration. They have to follow this process. When an agency establishes a process, they are bound to fully comply with it. That's what this court held in Soto versus Board of County Commissioners Hernando, 716. Not only must they follow its rules, but they must fully follow the rules. The court here, not this court, the ALJ, found in 4 different places within its order where the court described how well they followed their order, what he determined their following of the order to be. In one paragraph, he said, the process of revisions was substantially complied with, and any deviation was insignificant. Well, there's case law that says a deviation from your policy is material. It's material error for a body to create a rule and then not to follow it, because it is inherent within government agencies that if they do not follow their rules, arbitrary action will follow. The Southern District said that adherence to established procedures is essential to prevent the kind of arbitrary action that is inherent in the violation by a government agency of its own rules.
So your position is that by the very fact that he found that the rule was substantially complied with, we have to reverse it and send it back?
Absolutely, because
substantial compliance isn't good enough.
It's not full compliance. He not only said substantial, Judge Griffin, he says it was followed as a practical matter. It was essentially followed. The policy and the parameters of the policy were followed to the extent adherence was possible and appropriate. What made it impossible or inappropriate to follow their rule? Absolutely, the law that stands out there says if you have a rule, you're going to follow it.
Well, if Step 9 says the board selects a plan alternative for consideration, did they do that? Did the board select a plan alternative for consideration?
Not within the confines of the policy, because I'm
just asking. The policy says, Step 9, the board selects a plan alternative for consideration. Did they do that?
And again, the answer, Judge Griffin, is not within the terms of the policy, because the only plan alternatives that could be selected for consideration within this policy are the ones prepared by the core committee. Did they select something that was given to them?
Didn't they select one of those for consideration?
Pardon me?
Didn't they select one of those for consideration?
No, they did not.
Didn't they select 3 of them for consideration? Didn't they consider 3 different plans?
Absolutely not. They never came to consider what came to before the court, the agency, was the one that went for the superintendent. If you mean at that meeting where they had 3 plans out there, where they went over those in a workshop, absolutely that did not happen. They had 3 core committee plans, the one that was submitted by the superintendent. There was no discussion on those plans with the core committee as required by this rule, not one discussion on the superintendent's, and there was a 5-minute presentation based on some chart that had been put together that was...
Well, within the superintendent, probably with the 5 plans, then the school board members have all 5 plans, and then when they got to the meeting, the superintendent said, you have 5 plans, I recommend, Z2 or whichever it was. But they had 5 plans submitted to them for consideration, even if they chose to speak about one of them, correct?
Well, I'm not sure if it's 5. I think it's 4 with a modification, or I'm not sure, Judge Evander, but whether it's 4 or 5. Yes, there were, the bigger distinctions, there was core committee plans unchanged that were provided for consideration, and there were, and there were the superintendent's plan. The superintendent got up and gave a recommendation. He did not discuss each one of the plans individually. According to Sunshine Law, this was the first time that this body would have seen any of these plans as a body to consider and vote it. Otherwise, it's a violation of Sunshine Law. In the discussion, the superintendent got up and said, well, I've done this methodology based on what I know you wanted. The testimony was he knew what they wanted. He knew what problems they had individually had said to him or a problem in the other plan. I have tailored a plan to meet this, so therefore my methodology tells you this is the best one, even though it was a flawed methodology, so you should recommend it. He didn't go through each one of the issues on the other plans. He didn't go through the core committee process with them. He didn't go through why the core committee had determined these plans to be acceptable and the specific provision he wanted to put in unacceptable. That didn't occur in that public meeting. All that occurred was we started it for consideration. Citizen after citizen after citizen moved up to the podium to give a 5-minute, this is wrong. You violated the process. You made an agreement with us. You engaged in negotiated rulemaking with us. You pulled us out of our homes, out of our teachers out of the schools, and our PTAs out to work in numerous meetings to do this, and then you deviated from your policy. Actually, you just flatly decided not to follow it, and now you're substituting it. And that, to answer Judge Griffin's previous question, if you're going to deviate from your policy, you have to do it by rulemaking. Case law is clear. If you think your policy is a lousy policy, change it. Certainly have that. It was their own policy. They created this policy. They created these procedures. They created these constraints upon their discretion. If they don't like it, change it. They didn't do it. What's their argument for that? Why didn't we change it? They said, well, it's implicit. The superintendent can always give a recommendation. When in negotiated rulemaking, that's actually not true. What's there is you make a deal with third parties, and it's at Section 120-54D. You involve them in the process, you accept what their process is going to be, and you agree to accept the results of their deliberations. That doesn't mention the superintendent.
What section or step in Policy J what language are you pointing to? What section are you pointing to that says that the school board may only adopt a proposal that has been recommended by the core committee?
You have to read the whole. It makes no sense. When you go through the policy, once it goes to, we're going to give all of our facts, step one. We're going to give them the materials. They're going to go through audits of enrollment. Then they're going to come up with plans. Those plans will go through a workshop, which debatably occurred or didn't occur, and then those plans will go for consideration.
Well, go for consideration is different than is to be accepted by. And I'm just asking you, what language are you relying on in this Policy J that says that the school board must accept a proposal made by the core committee?
I have to get to that page in my brief. Hold on just a second, if you don't mind. I believe it's step 8 and step 9. Your Honor, because in those, it references the only plans that are referenced in the whole policy.
All right, thank you.
Yes, sir. It's step 7. The committee revises its alternate plans based on public input. Only the plans that they have created. Step 8. The committee scheduled a public work session with the school board to review the final plan recommendations. Didn't happen. The board selects a plan alternative for consideration. The only plan alternative mentioned in this policy are the ones that are created by the core committee. We could say they could select the one that the milk plan gave them, Judge. But that person's not in here either. They could say the superintendent. If you look at the agency's post-unitary policies, they say it's implicit, but when they created these new policies for when they got out from under federal oversight, they included within that policy specifically that the superintendent will submit his own plans. If it's implicit, why include it? It's not implicit. This is negotiated rulemaking. They're obligated to follow what the core committee gave them, or reject it and go back to a core commission and say, work on it again. Either way, we expect our children to follow rules. The government, this court, expects us to follow rules. We should be able to expect our government agencies to follow rules, particularly those rules that they themselves have created. They didn't want to follow them. They go into negotiated rulemaking and change it. They don't breach the trust of the community. They don't breach their rules, and they don't act in an arbitrary fashion. Secondly, within the order, the judge sought to harmonize statutes with the policy J. Well, first thing the court did that was...
I don't mean to interrupt you. I just wanted to let you know you're down to about 4.5 minutes.
Yes, ma'am. Thank you. First, we don't go into statutory construction unless a rule is vague and ambiguous. This is clear. Secondly, specific rules apply over general rules. All the statutory sites set forth by the ALJ and by the agency are general in nature as to general rules, not as to specifically assigning students in the recommendation of the superintendent. They had the power to create a process as long as it didn't violate any rules, and it did not. It certainly didn't violate negotiated rulemaking, which completely cuts out superintendent. They even included him in making him control of the meeting. So the ALJ engaged in unnecessary and wrongful statutory construction. And as a final issue I'd like to address is agency's deference. There's a lot of that in the... If we have a rule, we can interpret it any way we want to. That was basically the argument. If we made a rule we don't like and we don't have time to change it because we got to get kids in new schools because we have an agenda to get to, then we will just interpret our rule the way we want. But this court and the ALJ was not designed, is not obligated to accept an interpretation, first of all, of an unambiguous rule. Secondly, that doesn't make any sense. They've grafted onto this rule something that isn't within the express language, and it's not even in the statutes that they rely upon. You don't have to accept that, and I submit to you that you should not. This case has been here a long time up at the Fifth, and it was in the trial court for a long time too. And there might be a belief on the court's behalf that, well, everybody's been moved around. What's going to happen now? I remember watching a movie with Alec Baldwin, and it was about the Medgar Evers trial and his murder. And in his closing argument, he said to the jury, his question to them was, is it ever too late to do what's right? Well, the answer is no. It's never too late. You can do what's right. All it takes is courage to do what's right. And we would submit to follow the precedent that's out there. The precedent says, if you make a rule, you're going to follow it. If you don't follow it, it's invalid. And based on that, we would ask the court to reverse, find it to be an invalid rule, and send it back and make them do it again, because that's what's right, and that's what is required and expected. I yield the balance of my time to rebuttal.
Thank you, counsel.
Thank you.
May it please the court, my name is Marcia Lippincott, here today together with Mr. Ned Julian, representing the School Board of Seminole County. Your Honors, there's no question here that the school board did what was right. The appellants ask you to consider policy J in a vacuum, but that's not right. That's not Florida law. The appellants completely ignore the Florida law. They contend that it's the sole responsibility of the school board to assign students to schools. But this statement ignores the statutory fact that a school superintendent is executive officer of the school board. A school board cannot act without considering the recommendations of the school superintendent. If you look at Florida Statute 1001.41, it says specifically that the district school board, after considering the recommendations submitted by the district school superintendent, shall exercise one of the powers to assign students to school. Listen carefully to the limitation on the power of the school board. It's after considering the recommendations submitted by the school superintendent.
Does the school superintendent have any input to or involvement with?
No, not expressly. The assistant school superintendent sort of directed the core committee and was the leader. The school superintendent in his person wasn't there.
The office of the school superintendent therefore had input into the
Correct.
plans proposed by the core committee, correct?
Correct. In addition, Florida Statute 1001.51 says that the district school superintendent shall perform all tasks necessary to make sound recommendations. In addition, 1001.49.1 says that the superintendent shall exercise general oversight over the district school system in order to determine problems and needs and recommend improvements. And in addition, the Florida Attorney General has stated regarding school personnel recommendations that the Florida School Code does not contemplate that the school board will adopt policies governing the superintendent's exercise of authority. 1001.32 says that all actions of district school officials shall be consistent and in harmony with state laws. And of course, also, if there's ever a conflict between a state statute and a rule, the superior state statute must always govern. What happened here is quite simple.
Well, are you arguing this was the superintendent's decision alone to make?
No, Your Honor.
Well, then what are you arguing?
I am arguing that the school superintendent not only had the power, but the duty to review the plans, to determine there was a problem, and to take those plans and use them to make 2 new hybrid plans and make a recommendation that one of those might be the better alternative. He not only had that power, but he had that duty to do so.
He had the duty to consider the core committee's recommendations.
He had the duty to consider those, and he did do that. And in fact,
where does that duty come from?
well, his duty is to do anything to make the school system better, or
Well, that's all very nice, but where in the procedures is the superintendent's relationship to the core committee?
I don't
He said
think,
he had the duty to consider their alternate plans and then make a recommendation.
I don't
on
think
his
there's
own.
an express statement that says that he has to consider those.
So then it's up to the superintendent. He doesn't have to consider the core
No,
committee.
the school board has the final decision as to what plan was adopted.
Well, the school
And they
board has,
exercise.
according to the appellant, the school board has laid out exactly what it intends to do. It intends to have a core committee that selects a plan, and they're either going to implement that plan or send it back. The
Your
fact
Honor.
that the superintendent has input in that process in advising the school board isn't in conflict with what the appellant is arguing.
Well, Your Honor, the statutes are very clear. The statutes are very clear that it's the superintendent's responsibility to make recommendations, to correct any problems that he sees.
Well, the superintendent made a recommendation here.
Yes, he did. And that's what the school board adopted, was his recommendation.
But where does the school board get the power to adopt his recommendation if the school board has already developed a policy delegating the authority to make those decisions to the core committee? That's what I'm having trouble with.
Well, Your Honor, as you yourself pointed out, when you look at policy J, as Judge Evander pointed out, there's nothing within the 4 corners of that policy that says that the school board can only consider plans submitted by the core committee. In addition, as you pointed out with respect to step 9 and the word consideration, In addition, you recall the testimony unobjected to of Dr. Haggerty, which said that this policy, which he drafted, was only supposed to be advisory, and that's the way it was used. And in addition, it would be contrary to Florida law for the school board to adopt a policy that took away the power of the school superintendent. That's simply not allowed by Florida law.
But didn't you say his only power is to make recommendations?
Yes, his power is
And he
to
made
make
a
recommendations.
recommendation.
He did make recommendations, yes.
Could the school board create legally establish a policy that says they must adopt a plan recommended by the core committee if it's the only plan recommended?
No, I don't think so. Because I think that would invade and take away the power of the school superintendent. I think that would be contrary to Florida law. I think then you'd have a conflict between the rule and the statute, and Florida law says that it's statute and governance. So no, I do not think that the school board could do that. I don't think that's what they did, and it wouldn't be correct if they did do that.
You made reference to step 9 of the plan, which says the board selects a plan alternative for consideration.
Yes.
Focused on the term for consideration, which
Yes.
I assume to argue that they only have to consider it, they don't have to approve it. Is that
Exactly.
correct? Is the term in step 9 for the selects a plan alternative, is that a plan prepared by or recommended by the core committee? That's what they've got to consider?
No, I don't think so.
So when step 9 says the board selects a plan alternative for consideration, what is the plan alternative for consideration that the board can select? Any plan they want?
Well, first, Your Honor,
Or is it only plans that are submitted by the core committee?
First, Your Honor, you're trying to look at policy J in isolation. Our argument is you can't do that. That you have to look at it in conjunction with the Florida statutes governing the school system.
Look
And
at
when
it
you
in
look at
conjunction with anything you want, but I'm trying to get an interpretation of this step of the plan, step 9.
Yes, Your Honor.
What
But-
plans can the board select for consideration under step 9? Any plan they want?
Yes.
So the argument from your opposing counsel that they could accept the plan from the milkman and do that would be correct.
Your Honor, there were lots of individual plans that people proposed to the school board that night that were considered.
Okay, and the board can consider and approve any of, they could consider a plan that had no involvement of the core committee, is your position?
I think so, yes. Absolutely. The school board of Seminole County followed the rules. The superintendent is charged with this responsibility to see a problem and correct it, and that's what he did. The core committee was not ignored. The new plan Z2 and Z3 were based upon the core committee plans.
Didn't the superintendent have the ability to address those problems by virtue of its representative on the core committee? And could address them by having the core committee consider what he considered defects and correct them in the core committee recommendation?
That's one way it could have been done. But it could also be done in the way it was done. There is nothing within the requirements of Florida statutes that prevents that. And again, we would respectfully submit that the superintendent would have been negligent in his duties if he hadn't done what he did. If he hadn't said,
If
I
he
see a
hadn't made
problem.
recommendations.
Exactly. Well, and if he hadn't said, I see a problem that needs to be corrected, and I'm correcting it. This is my recommendation. He had a
If the school
responsibility.
board had rejected his recommendation under Florida statutes, would that have been okay?
The school board has final authority. So,
So the school board had the power to reject the superintendent's statutory fulfillment of his duties.
well, the superintendent has the obligation to
Recommend.
see problems, recommend, but at the
But
school
once he's
board,
recommended, then the school board can
school board
completely
has
disregard what he
the
said.
obligation to act.
And the school board then would have the power to say to a superintendent, if you got a problem with plans, take it to the core committee.
I presume they could have said that.
And is that what they said by this plan? Because this plan sets up a core committee and contemplates that those plans will come before the board for acceptance or rejection?
Would you ask me that one more time?
Sure. You said that the school board could say to the superintendent if they wanted, if you got a problem with the plan, here's a procedure we're going to set up for you. Go take it to the core committee and let them deal with it, and then we'll consider the core committee plans, right?
I don't think that they could put those, I don't think that the school board could put those limitations on the school superintendent. And I think Florida law says that fully. They can reject what the superintendent recommends, but I don't think they can order him to carry out his duties in a specific way. No. Your Honors, the public was fully involved in this rezoning process. There were over 1,600 people involved from the general public with respect to this rezoning that attended numerous hearings regarding this matter. This wasn't something that was kept in secret.
Now, are these numbers you're talking about of the people who participated in core committee proceedings?
Throughout the process, the 3 core committee meetings, the 2 public input committees.
So that same argument could be made if the school board adopted a plan that had nothing to do with the core committee. I mean, if they'd come up with a totally different plan all on their own, you'd be able to stand there and say, but 1,600 people participated in this process, right? What good is the 1,600 people participating in the process if the school board then isn't going to limit its consideration to those plans that come out of the core committee where those people participate?
Okay, first of all, Plan Z2, which was the plan that was adopted, did not just come out of the air. It came from the plans recommended by the core committee.
But I understand your argument is they could have just adopted a plan out of the air and it would have been no violation, correct?
Yes, they could have. But this plan, Z2, was before the public, before the October 26th meeting of the school board. Mrs. Finch, one of the leading petitioners, admitted that, yes, she was familiar with Plan Z2. It was published. It was out there for the public to see. It was discussed over a 7 or 8 hour school board meeting in depth. She admitted that everyone who wanted the opportunity to speak had the opportunity to speak regarding this plan. It's not something that was just drawn out of the air, that people didn't have notice about, and that wasn't thoroughly discussed. It was thoroughly discussed ad nauseum.
But what's the relevance of any of that to your argument, since your argument is the school board can pick any plan it wants, including one that didn't come from the core committee? So what's the relevance of your argument? But in this case, they took one and modified it or gave some notice of it. If your legal argument is they can adopt any plan they want.
I'm just stating the facts of what happened in this situation.
But what's the relevance of that to your legal argument?
I'm just responding to the arguments made by the other side. But I think the school board could adopt whatever plan they found would do the best job for the children, citizens of Seminole County, and that's what they did. And again, the school superintendent would have been negligent in his job if he hadn't done what he did, was simply to say, I recognize the problem, needs addressing. Here's what I think is the best recommendation, and that's what the school board adopted. Any further questions? Thank you, Your Honor. We'd like you to affirm the decision of the ALJ. Thank you.
Thank you, counsel.
Mr. President, let me tell you a concern I have and see if you can put this concern to rest. The school board has the obligation, responsibility to determine attendance zones, correct?
Yes, sir.
I mean, they have the ultimate authority. By statute, they're the ones that have to determine.
Agreed. Yes, sir.
All right. And you got asked before about if they got one proposal. I think one time you said they have to accept it, another time you said they can send it back. Well, let's say they send it back and it comes back again. I mean, does the school board have the legal right? Are they legally able to say, Whatever the committee decides, we will follow.
Yes, sir. And I think that is found in Section 120-54D. The requirements there for negotiated rulemaking. They didn't call it that, but if it looks like a duck, walks like a duck, it's a duck. Well, this duck says they'll uses the committee of designated representatives to draft a mutually acceptable rule. That's what they did. And one of the representatives happened to be the superintendent's office. So they didn't just disregard the superintendent. The next is, it's usually used for complex rules. This negotiated rulemaking, clearly this is a complex rule. Finally, it says, for rulemaking to occur, the agency must determine that it is going to support the work of the negotiating committee. So can they? Yes, by statute they can do that. They didn't cut out the superintendent's recommendation. It was incorporated within the committee. But what they said they would do after that is, when you come up with a plan, we're going to accept it, and if not, we'll send it back till we get one. With the superintendent, he could have went right back to another meeting and said, these 6 things aren't any good, I'm not going to recommend it, change the plans accordingly, and I'll send it up. They didn't do that. You can't just throw the process out the window because you don't like the result. And they clearly knew that the superintendent was not a part of this process, and they engaged in negotiated rulemaking because they put him in the post-unitary rule. The last thing I'd like to say to the court is, Mr. Haggerty's testimony was brought up as someone who indicated this was meant to be advisory. Cited in your reply brief, the testimony of legislative people after the fact has zero probative value. You can get anybody to say anything you want. Well, I meant it to be this, I meant it to be that. As the legislators who drafted this rule, it was incumbent upon them to make it explicit if they wanted that to be in it. They did not. Thank you for your time, and go Gators.
All right, well, you got 2 out of 3 votes there. And for Judge Palmer's benefit, you go Big East. Boston College?
Yeah.
Okay, never mind then. We're behind the time.